for more. Doctrine of anticipatory breach. The doctrine holding that even if the contract is divisible in its performance and the future periodic deliveries are not yet due, if the obligor has already manifested his refusal to comply with his future periodic obligations, the contract is entire and the breach total, hence there can only be one action for damages. Blossom & Company, Incorporated v. Vanilla Gas Corporation, GRL 32958, November 8, 1930, 55 Fel 226. Subscribe for more. Doctrine of Apparent Authority. The doctrine under which the acts and contracts of the agent, as are within the apparent scope of the authority conferred on him, although no actual authority to do such acts or to make such contracts has been conferred, bind the principal. The principal liability, however, is limited only to third persons who have been led reasonably to believe by the conduct of the principal that such actual authority exists, although none was given. In other words, apparent authority is determined only by the acts of the principal and not by the acts of the agent. Bennett v. Phil. Countryside Rural Bank, Incorporated, GR 163825, July 13, 2010, 625 SCRA 21. Also called the holding out theory, or the doctrine of ostensible agency, or agency by estoppel, or apparent authority doctrine. Or doctrine of attractive nuisance. A legal doctrine that makes a person negligent for leaving a piece of equipment or other condition on property which would be both attractive and dangerous to curious children. These have included tractors, unguarded swimming pools, open pits, and abandoned refrigerators. Liability could be placed on the people owning or controlling the premises even when the child was a trespasser who sneaked on the property. Also called attractive nuisance doctrine. Subscribe for more. Doctrine of assumption of risk. The precept that denotes that a person who knows and comprehends the peril and voluntarily exposes himself or herself to it, although not negligent in doing so, is regarded as engaging in an assumption of the risk and is precluded from a recovery for an injury ensuing therefrom. Also doctrine of felony non fit injuria. Subscribe for more. Of caveat emptor. A warning that notifies a buyer that the goods he or she is buying are is, or subject to all defects. The principle under which the buyer could not recover damages from the seller for defects on the property that rendered the property unfit for ordinary purposes. The only exception was if the seller actively concealed latent defects or otherwise made material misrepresentations amounting to fraud. Also doctrine of let the buyer beware. Subscribe for more. Doctrine of benevolent neutrality. Constitutional law. The doctrine holding that freedom to carry out one's duties to a supreme being is an inalienable right, not one dependent on the grace of legislature, and religious freedom is seen as a substantive right and not merely a privilege against discriminatory legislation. With religion looked upon with benevolence and not hostility, benevolent neutrality allows accommodation of religion under certain circumstances. Estrada v. Escritor MPO 2-1651. August 4, 2003, 408 SCRA 1. Subscribe for more. Doctrine of auto limitation. The Philippines adheres to principles of internal law as a limitation to the exercise of its sovereignty. Prior judgment law. A concept of res judicata holding that when, as bet, the first case where the judgment was rendered and the second case that is sought to be barred, there is identity of parties, subject matter, and causes of action. In this instance, the judgment in the first case constitutes an absolute bar to the second action. Antonio v. Saman v. Dieta Monge, GR 149624, September 29, 2010, 631 SCRA 471. Subscribe for more. Doctrine of command responsibility. The doctrine under which any GOVT, official or supervisor, or officer of the PNP or that of any other law enforcement agency shall be held accountable for neglect of duty if he has knowledge that a crime or offense shall be committed, is being committed. Doctrine of class suit or virtual representation. A doctrine based on the concept that members of a class who are made parties will protect their own interests, which are such that in protecting them the interests of the persons not made parties will also be protected. 67 CJS 919. Subscribe for more. Doctrine of collateral estoppel. A doctrine that prevents a person from relitigating an issue. Once a court has decided an issue of fact or law necessary to its judgment, that decision precludes relitigation of the issue in a suit on a cause of action involving a party to the first case. Also doctrine of preclusion of issues. Subscribe for more. Doctrine of collateral estoppel. A doctrine that prevents a person from relitigating an issue. Once a court has decided an issue of fact or law necessary to its doctrine of command responsibility. The doctrine under which any govt, official or supervisor, or officer of the PNP or that of any other law enforcement agency shall be held accountable for neglect of duty if he has knowledge that a crime or offense shall be committed, is being committed, or has been committed by his subordinates, or by others within his area of responsibility and, despite such knowledge, he did not take preventive or corrective action either before, during, or immediately after its commission. Sec 1, EO 226. Feb. 17, 1995. Subscribe for more. Doctrine of command responsibility. The doctrine under which any govt, official, doctrine of class suit or virtual representation. A doctrine based on the concept that members of a class who are made parties will protect their own interests, which are such that in protecting them the interests of the persons not made parties will also be protected. 67 CJS 919. Subscribe for more. Doctrine of class suit or virtual representation. A doctrine of collateral estoppel. A doctrine that prevents a person from relitigating an issue. Once a court has decided an issue of fact or law necessary to its judgment, that decision precludes relitigation of the issue in a suit on a cause of action involving a party to the first case. Also doctrine of preclusion of issues. Subscribe for more. Doctrine of collateral estoppel. A doctrine that prevents a doctrine of checks and balances. A doctrine in constitutional law that allows one department to resist encroachments upon its powers and prerogatives by the other depths or to rectify the mistakes or curb the excesses committed by the other depths. Also called checks and balances doctrine. Subscribe for more. Doctrine of checks and balances. A doctrine in constitutional law that allows one department to resist encroachments upon it. Doctrine of constitutional avoidance. The doctrine in constitutional law prescribing that the court should refuse to rule on a constitutional issue if the case can be resolved on another ground. Subscribe for more. Doctrine of comparative negligence. The doctrine that allows a recovery by a plaintiff whose own act contributed to his injury, provided his negligence was slight as compared with that of the defendant. Regs v. The Atlantic, Gulf and Pacific Colorado, GR 1719, January 23, 1907, 7 Phil. 359. Subscribe for more. Doctrine of comparative negligence. The doctrine that allows doctrine of condonation. The doctrine that a public official cannot be removed for administrative misconduct committed during a prior term, since his re-election to office operates as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore. The foregoing rule, however, finds no application to crim. Cases pending against petitioner. Aguinaldo v. Santos, Gr. 94115, August 21, 19. Doctrine of Compassionate Justice. The doctrine that the harsh provisions of law and the rigid rules of procedure may sometimes be tempered and dispensed with to give room for compassion. Subscribe for more. Doctrine of Compassionate Justice. Doctrine of Conclusiveness of Judgment Law. A concept of res judicata, holding that where there is identity of parties in the first and second cases, but no identity of causes of action, the first judgment is conclusive only as to those matters actually and directly controverted and determined, and not as to matters merely involved therein. Stated differently, any right, fact or matter in issue directly adjudicated or necessarily involved in the determination of an action before a competent court in which judgment is rendered on the merits is conclusively settled by the judgment therein and cannot again be litigated but the parties and their privies, whether or not the claim, demand, purpose, or subject matter of the two actions is the same. Antonio v. Simon v. Dieta Monge, Gr. 149624, September 29, 2010, 631 SCRA 471. Doctrine of Comparative Injury. A rule in equity which states that although a person is entitled to injunctive relief, if the injury done to the respondent or the public would be disproportionate, then injunctive relief must be denied. Subscribe for more. Doctrine of Comparative Injury. A rule in equity which. Doctrine of Command Responsibility. Elements are the following: a. The existence of a superior-subordinate relationship bet. The accused as superior and the perpetrator of the crime as his subordinate. b. The superior knew or had reason to know that the crime was about to be or had been committed. And c. The superior failed to take the necessary and reasonable measures to prevent the crime, acts or punish the perpetrators itself. Subscribe for more. Doctrine of Completeness. The doctrine holding that a dying declaration to be admissible must be complete in itself. To be complete in itself does not mean that the declarant must recite everything that constituted the res gestae of the subject of his statement, but that his statement of any given fact should be a full expression of all that he intended to say as conveying his meaning in respect of such fact. People v. De Gioia, Gr. 75028, November 8, 1991, 203 SCRA 343. Subscribe for more. Doctrine of Completeness. The doctrine holding. Doctrine of Constructive Compliance. The doctrine that states that if, without the fault of the heir, the modal institution cannot take effect in the exact manner stated by the testator, it shall be complied with in a manner most analogous to an inconformity with his wishes. Art. 883, cc. Doctrine of Constructive Trust. A general principle that a person who acquires land or other property by fraud, misrepresentation, imposition, or concealment, or under any such other circumstances as to render it inequitable for him to retain the property, is an equity to be regarded as a trustee ex maleficio thereof for a person who suffers by reason of the fraud or other wrong, and is equitably entitled to the property, even though such beneficiary may never have any legal estate therein. Magellan v. Montijo, Gr. 73733, December 16, 1986, 146, SCRA 282. Doctrine of Constitutional Avoidance. The doctrine in constitutional law prescribing that the court should refuse to rule on a constitutional issue if the case can be resolved on another ground. Subscribe for more.